And today, the Supreme Court has answered that question by a vote of 6-3.
The U.S. Supreme Court has just issued a major ruling.
Major Second Amendment case.
Major Supreme Court ruling.
The Department of Justice just did the unthinkable. They filed a 47-page confession of error, publicly admitting that federal laws regulating firearm suppressors are unconstitutional. This wasn't a quiet memo or a minor policy shift. This was a systematic public dismantling of 90 years of federal gun regulation, engineered by the same government attorneys who had spent $500,000 defending those regulations just months prior. This unilateral surrender was designed as a strategic retreat, a calculated attempt to stop a complete collapse of the National Firearms Act. But it failed spectacularly because the Ninth Circuit Court of Appeals refused to play along. A unanimous Ninth Circuit opinion just landed, striking down the entirety of the NFA's suppressor provisions. This decision, United States versus Patterson, changes everything for 6 million registered owners and fundamentally redefines how courts view every single NFA item going forward. We have to understand the legal chess match that led to this moment. The core reversal occurred on January 20th, 2026. Acting Associate Attorney General Benjamin Williams filed that critical confession of error. He admitted the federal government could no longer defend the taxation and registration of suppressors under the Supreme Court's new Bruen standard. Think about the magnitude of this admission. The DOJ conceded that the $200 tax stamp functions as a financial barrier that prices poor Americans out of their fundamental rights. They admitted that with 2.6 million registered units, suppressors are clearly in common use for lawful purposes. This wasn't limited to the Ninth Circuit. DOJ attorneys simultaneously filed notices of position change in 6 different circuit courts, withdrawing opposition to suppressor challenges from Arizona to Maine. Government lawyers suddenly dropped cases they had been litigating aggressively for 3 years. But here is the tactical error. The DOJ specifically warned the court that this admission applied only to suppressors. They tried to create a containment strategy, hoping the courts would simply grant relief for the most sympathetic NFA category, a hearing protection device, and leave the rest of the National Firearms Act, including machine guns and short-barreled rifles, intact. The Ninth Circuit panel saw the maneuver, but they refused to honor the boundaries the government tried to draw. This case started with Michael Patterson, a competitive shooting instructor in Scottsdale, Arizona. He wasn't seeking to be a constitutional plaintiff. He purchased a suppressor specifically to protect his hearing after years of teaching had caused permanent damage. He followed every requirement, submitted fingerprints, paid the $200 tax stamp, and notified the local sheriff. He waited 11 months and 17 days for the ATF approval. The Firearms Policy Coalition approached him, challenging not just the weight, but the constitutional basis of the entire NFA framework for suppressors. The district court agreed, ruling in September 2024 that suppressors clearly meet the criteria for Second Amendment protection. That's when the real fight started. The DOJ appealed immediately to the most hostile appellate court in the country, the Ninth Circuit nightmare. Everyone expected to lose this appeal. The Ninth Circuit had ruled against gun rights claims in 23 consecutive cases since the Bruen decision landed in 2022. They upheld every major California, Hawaii, and Washington restriction imaginable. The 3-judge panel assignment was terrifying. Judge Watford had upheld mandatory 10-day waiting periods. Judge Horowitz had upheld Hawaii's ban on openly carrying firearms. Judge Angwin had never voted to strike down a single gun regulation in her entire judicial career. Gun rights groups budgeted for an anticipated loss, expecting to fight the case later at the Supreme Court. The government's confession of error, filed 1 week before the scheduled oral argument, changed the battlefield instantly. Instead of the anticipated loss, Patterson won everything. This is the core legal insight that doomed the government's case. If you value understanding how the Second Amendment actually works in court and how these historic challenges are changing the legal landscape, hit that subscribe button right now and join the Law Advisor community. The Bruen standard requires that any firearms regulation must be consistent with the nation's historical tradition of regulation from the founding era. The government is forbidden from using modern interest balancing tests. The problem for the NFA is simple. Suppressors weren't invented until 1902. There literally cannot be any historical regulations of suppressors from 1791 because they didn't exist yet. The DOJ spent 7 months searching for historical analogs that could justify the registration and taxation. They found nothing that survived scrutiny. A $200 tax on a hearing protection device has no historical parallel. That's why the DOJ had to confess error rather than defend the indefensible. Chief Judge Jacqueline Nguyen's 89-page opinion is being called the most important Second Amendment decision since Heller. Crucially, all 3 judges, the same judges expected to destroy the case, joined every section of the ruling, making it binding precedent across 9 Western states. The opinion rests on three independent pillars that systematically destroyed the NFA framework for suppressors. Pillar 1 addressed the common use requirement. The government argued that 2 or 6 million suppressors are still unusual. Judge Nguyen demolished this by pointing out that when Heller was decided, there were only 1.5 million AR-15 rifles in civilian hands, yet the court specifically cited them as protected arms in common use. Suppressors are protected. Pillar 2 tackled the tax as a prior restraint. The court found that $200 in 1934 is the equivalent of $600 today. The average suppressor costs $600. Therefore, the tax functions as an 800% levy on the exercise of a constitutional right. No other fundamental right can be taxed at 800% of its exercise cost. Pillar 3 addressed the waiting period. The court found that a 9 to 12-month delay in exercising a constitutional right, with no maximum time limit and no recourse, if the government simply never processes the application, constitutes a de facto ban. Patterson waited nearly a year after already passing an instant background check. Judge Nguyen didn't just strike down the law, she included a detailed 90-day implementation timeline designed to prevent chaos. This is critical. Effective immediately, as of January 23, 2026, the ATF must stop collecting the $200 tax stamps for new suppressor purchases. Anyone buying a suppressor after this date pays only for the item itself, and undergoes a standard unanimous background check identical to purchasing a handgun. No fingerprints, no photographs, no ATF Form 4, and no waiting period beyond the instant check processing time. For the 347,000 people currently waiting on pending Form 4 applications submitted before January 23rd, the ATF has 14 days to auto-approve all applications pending a successful NICS recheck. Within 90 days, the ATF must refund all $200 tax stamp payments for applications submitted after January 1st, 2024. That is approximately $69, $4 million in refunds. Most significantly, the court ordered that all persons currently in lawful possession of any firearm are deemed lawful possessors of suppressors without registration. The NFA registry for suppressors becomes obsolete. The legal reasoning here doesn't stop at suppressors. Judge Nguyen included a 20-page section of guiding statements, dicta, that systematically apply the exact same Bruen analysis to short-barreled rifles and shotguns. Short-barreled rifles, defined as rifles with barrels under 16 inches, have been NFA items since 1934. The government's justification has always been their concealability, but the opinion points out that millions of Americans legally carry concealed handguns in all 50 states after Bruen struck down restrictive permitting. Furthermore, there are 2 million AR-15 pistols and braced firearms in civilian hands, all with barrels under 16 inches, all legal, and all in common use for defense. Judge Nguyen wrote that she could find no principal distinction between an AR-15 pistol with a 13-inch barrel and an AR-15 rifle with a 13-inch barrel, except that one requires a $200 tax and one does not. 3 separate lawsuits challenging the SBR provisions were filed within 18 hours of the Patterson decision, all in the Ninth Circuit, specifically to take advantage of this binding precedent. Legal experts assign these cases a 95% probability of success because the government has already admitted it cannot defend arbitrary barrel length restrictions under Bruen. Here is the problem nobody is talking about. This is a federal court decision striking down federal law. 8 states still have their own suppressor bans written into state criminal codes that exist independently of the NFA. If you live in California, New York, New Jersey, or Hawaii, you are still violating state felony laws if you possess a suppressor, even though federal law no longer prohibits it. However, the legal pathway is clear. The 14th Amendment incorporates the Second Amendment against the states. If the federal NFA provisions violate the Second Amendment, then identical state provisions must also violate the Second Amendment. Gun rights attorneys estimate that state suppressor bans in at least 5 of the 8 states will fall within 12 months simply by applying the Patterson logic directly to the state statutes. But the ultimate threat to the NFA lurks in the most regulated item of all, the machine gun question. Does this decision open the door to challenging the Hughes Amendment, which banned civilian possession of machine guns manufactured after 1986? The constitutional analysis is harder for machine guns because of the Miller decision from 1939, but Patterson provides a massive opening. The Patterson opinion specifically states that the government cannot argue something is unusual when the government's own regulations prevent it from becoming common. The Hughes Amendment has artificially prevented machine guns from being in common use by freezing the supply for 40 years. If the pre-1986 growth rate had continued, there would easily be over 2 million registered machine guns today, meeting the common use threshold. Second, Patterson holds that registration and taxation requirements are unconstitutional prior restraints. The Hughes Amendment doesn't just tax or register machine guns, it bans them entirely for civilians. If a $200 tax and registration violates the Second Amendment, an absolute ban certainly does. The Firearms Policy Coalition has confirmed they are preparing a Hughes Amendment challenge to be filed in the Fifth Circuit, the most gun-friendly appellate court. The NFA is crumbling in real time, and most gun owners have no idea this is happening. Thanks for watching, and don't forget to like and subscribe for more legal breakdowns. And remember, stay safe, stay smart, and never forget, knowledge is the ultimate defense. I will see you in the next one.